In our study of the Indian Penal Code, we have now reached the last leg of chapter 16, and in this portion, we'll be learning about sexual offenses. The first and the most prominent sexual offense is rape. The offense of rape is defined in section 375. The definition of rape as it now appears in section 375 was substituted in 2013 by the Criminal Laws Amendment Act of 2013 as an aftermath of the Nirbhaya gang rape case of December 2012. This provision became effective from 3rd of February 2013. The definition of rape as it now appears in section 375 is drastically different and several times wider than what it was earlier before its substitution in 2013. Also, the meaning of the term rape as it appears in section 375 is drastically different from the way it is understood by the common people in common parlance. The scheme of the present section 375 is as under. In the first part, section 375 lists out a series of acts in clauses A to D. This list is followed by another list of 7 circumstances. In the second part, any of the acts which is listed in the first part in clauses A to D constitutes rape if it is performed in any of the circumstances which are mentioned in the second part. Here is the definition. A man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra or anus of a woman, or instead of himself so penetrating, he makes her to do so, and not only with him but also with any other person. This is clause A. Clause B says, a man commits the offense of rape if he inserts any object or part of body, not being penis, into vagina, urethra or anus of a woman, or instead of himself inserting the object or part of body, he makes her to do so, not only with himself but with any other person also. Under clause C, a man is said to commit the offense of rape if he manipulates the body of a woman to cause penetration into vagina, urethra, anus or any part of the body of such woman, or instead of himself manipulating the body of the woman, makes her to manipulate her own body so as to cause penetration as specified above. And lastly, in clause D, a man commits the offense of rape if he applies his mouth to the vagina, anus or urethra of a woman, or makes her to do so with him or any other person. These are the several acts, any of which will constitute the offense of rape if it is coupled with any one of the 7 circumstances now following. These are the circumstances. If the act of the man is performed under any one of these 7 descriptions, then it will constitute rape. The first circumstance is if the act is performed against her will. Secondly, if the act is performed without her consent, or the act is performed with her consent but the consent has been obtained by putting her in fear of death or in fear of hurt, or instead of putting her to this fear, by putting any other person in such fear in whom she is interested. Fourthly, if the act is performed with her consent, but the man performing the act knows that he is not her husband, and he also knows that the consent of the woman is given because she believes that he is another man to whom she is lawfully married or believes herself to be lawfully married. Fifthly, if the act is performed with her consent, when at the time of giving such consent, she was unable to understand the nature and consequences of the consent which she gave, and she was unable to understand the nature and consequences by reason of unsoundness of mind or intoxication or administration by the offender personally or through another of any stupefying or unwholesome substance. Sixthly, if the act is performed with or without her consent to a woman who is under 18 years of age. So any of the acts specified in clauses A to D, if performed to a woman under 18 years of age, will constitute rape, whether it is performed with her consent or without her consent. And lastly, if the act is performed when she is unable to communicate consent. We shall now make a short analysis first of the acts and then of the circumstances. The key word in the first clause is penetration of penis. The key word in the second clause is insertion of any object like a stick, insertion of any part of a body other than penis like a finger. In the third clause, the key phrase is manipulation to cause penetration. Here something is missing. It's not clear as to penetration of what. From the context, it seems that it should have been penetration of penis. And in the last clause, the key expression is application of mouth. Coming to the circumstances, the first circumstance is against the will of a woman. The second circumstance is that the act is done without the consent of the woman. But in the third, fourth and fifth circumstance, consent of the woman is there. However, the consent is vitiated and therefore is not valid. Under the third circumstance, the consent is obtained by putting the woman in fear of death or of hurt. In the fourth circumstance, the consent is given by the woman under a misconception that the man concerned is lawfully married to her. And in the fifth circumstance, she gives her consent without understanding the nature and consequences of the consent, and this happens because she is under the influence of intoxication or she suffers from unsoundness of mind. In the sixth circumstance, her consent has no meaning because she is under 18 years of age. She is below the age of consent as far as Section 375 is concerned. And in the seventh circumstance, she is unable to communicate her consent. Since consent is the key term in 5 out of these 7 circumstances, it's important for us to understand the scope and meaning of this term. It has been explained by way of explanation 2 to Section 375 in the following terms. Consent means an unequivocal voluntary agreement when the woman by words, gestures or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act. So there must be an unequivocal voluntary agreement. It should be voluntary, it should be unequivocal without any hesitation or doubt. And there should be a clear communication of the willingness of the woman to participate in the sexual act and only in that specific sexual act which is being committed. In addition to this explanation, we also have the provisions of Section 90 IPC where certain consents are declared as not valid. Firstly, a consent which is given under fear of injury or under a misconception of fact is not a valid consent if the person doing the act knows that the consent was given in consequence of such fear or misconception. Under the second paragraph, a consent which is given by a person who is unable to understand the nature and consequence of the consent because of unsoundness of mind or intoxication is not a valid consent. This provision reappears in section 375 in the form of the fifth circumstance. While on the topic of consent, we shall now answer a question whether a consent obtained through a promise of marriage is vitiated if that promise is not fulfilled subsequently.